Supplementary. Supplementary list fresh admission item number 1.
None appears.
Supplementary list fresh admission item number 2.
None appears. Dismissal not possible.
No instruction, my lord.
All right. Council with the latest states no instructions.
Supplementary item number 3.
Dismissal not possible.
Supplementary list item number 4.
None appears. Dismissal not possible.
Supplementary list item number 5.
None appears. Dismissal not possible.
Supplementary list item number 6.
Item number 6, that is issue regarding 148 notice post April 2021 and similar matter adjourned to 7th April March at 2 p.m. So same order.
7th March. No coercive steps. Who's for the department?
That is Chimanka.
Mr. Chimanka accepts notice. Same. All right.
Supplementary list item number 7.
May I please, your lordship?
Yes. Yes.
Let the registered cooperative society who has no authority has made the amendment to the staff service rules under Annexure 3, your lordship, at page 21. In exercise of the power conferred me under section 33A of the OCS Act, I, B.N. Malik, IAS Register of the Cooperative Societies Orissa, do hereby amend the Rule 7A of the Human Resources Policy for the State Government, State Cooperative Bank of Orissa, incorporating the staff service rules in 1980. Your lordship may kindly have a glance at this point to the provision under Rule 33, Section 33A. My lord, Section 33 2 provides.
So, but this is a 2014 rule that you are challenging, right? Amendment.
My lord, this has not been acted upon, and your lordship kindly have a glance to Annexure 4. The same register, by realizing this is a mistake, has issued a letter to the government. Page 24, your lordship may kindly have a glance. Inviting reference to the above notice of this is addressed to the Commissioner cum Secretary by the Registered Cooperative Society.
I see.
Inviting
All right.
reference.
All right. All right. Notice. Mr. Monty
Yes, sir.
accepts notice for opposite party number 1. What about Registered Cooperative Society? Is a different panel?
No.
It is the state, my lord.
Government.
Aha. So, except NABARD, why is NABARD and all made a party?
Because the statute provides in consultation with the NABARD, they will change the service conditions.
All right.
I will take notice to 3, 4, and 5 by speed post or registered post, whatever.
We will be appearing for 1 and 2 only.
1 and 2. Notice to the remaining opposite parties by registered speed post. Tracking report be placed in record. Replies be filed within 8 weeks. Joined up the next date. 22nd June, sir.
Oblige. I have filed a miscus in the meantime.
Yeah, notice on that. No notice on that. Yeah.
Oblige.
Supplementary item number 8.
My lord, I have given a note. The matter spreads over 30 years around. Therefore, this note will be much of assistance to your lordship. My lord, the petitioner challenged the Orissa Municipal Laws Amendment Ordinance 2021, void Ordinance number 3 of 21, thereby deleting, withdrawing, excluding reservation of seats in favor of backward
Yeah,
class.
this is because of the Supreme Court judgment.
Yes.
My lord,
They're
but
implementing the Supreme Court judgment.
triple test.
That's the point.
My lord, triple test is already 2 steps are over. State Commission for Backward Class has joined his post, number 1. Number 2, he has made a survey throughout the state, but it is not known to the public whether the report has been submitted to the state and
Maybe
advice
it's
has
not
been
ready.
given.
Maybe not ready yet.
Yeah, I'll issue notice. We'll file a report.
Or notice. Mr. Monty accepts notice or Mudali.
Yes, well.
All right. Whoever accepts notice for the opposite 1 and 2. So why Union of India is not a party at all?
Miller?
Union of India is not a party, sir.
Because because of the view given by Union and
No,
of
no,
India.
you may be given, no relief is being sought.
No, no relief. has been.
You say Union of India is not a necessary party and is accordingly deleted from the area of parties.
Commission has been engaged as a party, implemented as a party.
All right, the
State-
amended memo of parties be filed, consolidated memo of parties be filed within a week. Notice to the State Election Commission, Mr. Rautre.
Mr. Rautra is appearing. She is there in VC.
I will appear.
So who's instructing you, sir?
Mrs. Panda. Mrs. Panda.
Mrs. Panda accepts notice on behalf of SC State Election Commission. Notice to opposite party number 4, pre-numbered opposite party number 4. Do you accept for them also?
Five
this?
also is not important because they are a statutory committee. We will file a reply that will cover this.
All right, all right.
But I have filed an interim application.
It will be a notice on that also, sir.
Mine.
Please.
My lord, item number 5, I was disconnected, my lord. Item number 5, my lord.
We'll come to that in a minute, sir. 1 minute. The replies
Fine.
we filed within 8 weeks, rejoined up to the next date. List on 29th June, sir.
Lordship, please.
Lord, 29th of March,
June.
notice.
Ah,
In the meantime, then I publish the notification. With respect to-
sir, anyway, that can't be stopped because I don't think the report is going to come out before that. If the report doesn't come out, they can't make reservations.
Survey has been conducted long since.
If the report is submitted in the meanwhile, you file an application. All right.
Well, that will not be known to us because that is a private communication to the state government. So let the commission be directed, the acquired class commission may directed to some, give a information to your lordship whether he has submitted the report or not.
I think they'll tell us.
I will file.
You say in the meanwhile-
inform my learned friend.
Yeah, while no interim directions are being issued at this stage, if the
No, no,
Orissa State Backward Classes Commission,
no,
bracket opposite party number 4, submits its report
no, no.
to the state government,
And if
this
the-
court will be kept informed
My lord,
forthwith.
my lord.
Fourth.
Orders item number 9.
No, 1 minute. He said 5. Yes,
Five.
5.
Item number 5, my lord.
Tell us.
This is a public interest litigation, my lord.
Hmm.
In the illegal construction over the Jolashoya and Gochor land, my lord. Earlier, the lordship may kindly turn to the certificate. Earlier, there was a direction by this honorable court in WBC number 22996/2013, my lord. Pursuant to that direction, my lord, the collector directed the Tahsildar to conduct an inquiry. And if your lordship may kindly peruse annexure 5, page 22, my lord, the inquiry report submitted by the Tahsildar. Page 23 is the relevant portion, my lord. The Tahsildar has clearly stated that the construction is per se illegal, my lord. Lordship may kindly come to page 23, the last paragraph, my lord. This may be stated that there is no surplus Gochar land available in the village Diniari. Today it came to my knowledge that they have completed the road without paying any heed to my verbal instruction dated 11/6/2020 and not to proceed with the work further. So the construction,
So they filed a reply saying they are not proceeding now because
they
of
have
this-
not supplied the copy of the counter affidavit to me.
Now
Para
they've
6 and-
categorically said because the dispute between groups of villagers, they've stopped the construction.
Para 6
My lord,
and 7.
your
And
lordship
the
may kindly peruse
contractor is
the report.
also left. His final bill has been settled.
I have not received the copy of the counter affidavit, my lord.
That's
So
okay. I'll ask him to serve you, but there's nothing left. You say a counter affidavit is been filed on 19 January 2021 by the Executive Engineer, Rural Works Division, Cuttack 2, Cuttack. A copy thereof be served on consent of the petitioner during the course of the day. Paragraph. In the said counter affidavit, it is categorically stated that the construction of road on the disputed portion of land has been stopped because of protest and obstruction by a group of villagers. Full stop. Since the matter could not be resolved, it has been decided not to proceed with the construction. And the agreement with the contractor has also been brought to an end. In that view of the matter, no further directions are called for in the present petition. It is disposed of.
obliged.
Supplementary item number 9.
My lord, item number 9 is the assessment order passed by the assessing officer under section 153A in pursuant to notice under section 153C of the Income Tax Act. brief facts of the case is that the assessee is engaged in contract works and also having some interest. But the land assessing officer has issued notice under section 153C on the ground that NSC worth of rupees 26,000 were seized from the residence of Sri Manoj Kumar Naik, which relates to the present appellant, and for which the notice has been issued. But this reason has not been recorded in the case of person where it has been searched. It has been recorded in the case of the appellant only, for which the satisfaction has to be mentioned in the case where the search has been made, not in the case of the person whose assessment is to be done. After the search,
You're the,
Yes.
will admit it.
No, my lord, Lordship, see, my lord, the Annexure 3, his sole grievance before the tribunal is addition of 4 lakhs rupees. That is totally factual issues now. So yeah, now he's raising that has not been reflected in the order.
No satisfaction. He says of the IO who.
But the fact remains is the only issue is 4 lakhs rupees. And 4 lakhs is cash deposit. That has been detected by the IO, assessing officer. And that has not been properly satisfied before the assessing, nor even the first appeal.
No, he's a 153 notice, C notice, 153C.
Yes. So that part over.
No, but cash was recovered in somebody else's residence.
No. He is claiming that his own cash. You will also see the finding.
cash, this is NSC worth 26,000 has been seized because I am a contractor of that organization and I have deposited certain NSCs for taking the place as a pledge to do. That NSC has been seized, for which they have issued notice in my case under section 153C, which is also illegal because 153 section does not empower to issue a notice. It is only empowers to assessing officer to issue the notice under section 153A and to pass the assessment order in the manner provided under section 153. But here the notice itself has been issued under section 153C, and the satisfaction is that 26,000 NSC worth has been seized from the residence of Sri Manoj Kumar Naik. But during the imputed assessment year, this 26,000 NSC has no relevance, for which the satisfaction that has been mentioned has no relevance in the present case, and for which the assessment order passed in pursuant to said satisfaction is illegal. So far as the amount of 4 lakh,
I think the point he's making is, did you raise this before that ITAT?
This has been raised in before the CIT appeal, who has passed the order that there is a valid satisfaction. Thereafter, this matter has been raised before ITAT that the order of the CIT appeal is illegal.
Where have you raised it in the ITAT?
ITAT has restricted only to 4 lakhs without touching upon the issue that has been raised before CIT appeal.
No. This para 2 of the impugned order, sir. Just come to para 2 of the impugned order of the ITAT.
Sir,
the assessor has raised the sole issue. So if this was wrong, you should have moved on to 253.
Yes.
Got it rectified.
Since this is a legal issue, this can be also.
No, not like that, sir. If you give up and you say this is the sole issue I'm arguing now, we can't allow you to argue.
No, that is never stated before ITAT. They have mentioned that it is the sole issue which has been.
No. If that is wrongly recorded, you should move the ITAT to get it rectified.
Then next issue is that 4 lakh that has been added. That is also itself is wrong because they have themselves admitted that assessee is engaged in the construction work and has disclosed his income under section 44 AD of the Income Tax Act, disclosing the said turnover, and in which if the assessee discloses the income under section 44 AD of the Act, assessee is not required to maintain the books of accounts. This bank account from where the deposit of 4 lakh has been found deposited during the course of business, this has been withdrawn from the said bank account and there has been deposit. And nowhere the assessing officer or CIT appeal or ITAT has stated that this bank account was not shown to the department or the turnover stated therein is less than the deposit made in the bank account, for which this bank account cannot be accepted as a part of the turnover. That is not disputed. Only dispute is that part of the deposit has been questioned that during the year you have deposited 4 lakhs on. You have deposited 4 lakhs for which there is no source. My submission before sir is that this 4 lakhs we have explained that this 4 lakhs is out of the withdrawal from the said bank account, and this has been admitted by the ITAT on learned ITAT in the page.
Listen, one thing. he was able to explain 2,95,000.
Yes.
Then why add entire 4 lakhs? They should have added only that 1 lakh.
Yes.
So we'll reduce it to 1 lakh.
Yes.
That will
can-
serve your purpose. You showed withdrawals from the bank for about 2,95,600.
That is admitted by all of them.
So only the differential amount should have been added.
No, that cannot be also, because legally it is also not permitted, because I am not maintaining the books of account in accordance with section 44 AD.
Sir, you had to explain the source of 4 lakhs. You could explain only 3 lakhs. Let 1 lakh
Sir,
be
I
added.
have to explain the source of 4 lakh if it is my investment under section 69.
Yes,
This is not my investment. This is a deposit during the year.
you're right.
This section says, my lord, is that if they want to add unexplained investment, if I have not disclosed the same in the return of income, then they have empowered to make that addition. Only after issuing notice under section 142(1), Roman 3, asking me the assets and liabilities I have in my possession at the end of the year, on the basis of which there will be addition. That should have been done. Without asking anything, they have made an addition under section 69. That is my whole submission,
All right.
sir.
The SSC is an appeal against an order dated 4th April 2011 of the ITAT. In IT SSA number 4/CTK/2010 for the assessment year 2002-03. Paragraph. At the outset, it must be noted that although the counsel for the SSC appellant sought to urge some legal issues arising under section 153 capital A read with section 153 capital C of the Income Tax Act 1961 bracket Act, this court is not inclined to permit him to do so, since from the impugned order in para 2, since in para 2 of the impugned order, it is categorically noted by the ITAT that, open quotation, the SSC has raised the sole issue challenging the addition of 4 lakhs made by the assessing officer and upheld by the learned CIT-A without appreciating the facts of the case properly, unquote. Paragraph. Consequently, the present appeal is being entertained confined to the following question, colon, was the ITAT justified in sustaining the addition of rupees 4 lakhs to the taxable income of the SSC, concurring with the views of the AO and the CIT bracket A, question mark. It is seen from para 4 of the, para 7 of the impugned order that the SSC was able to demonstrate, was able to explain some portion of the sum of rupees 4 lakhs by placing on record details of the withdrawals from bank accounts to the extent of rupees 295,600. If indeed an explanation was offered for the above amount, there was no justification for sustaining the addition of the entire sum of rupees 4 lakhs. At the highest, the addition should have been of the amount constituting the difference between 4 lakhs and 2,95,600. Paragraph. Counsel for the SSC sought to argue that he was not even obliged to give an explanation for the sum of rupees 4 lakhs, since it was not even cash belonging to him and not found in the course of the search in his premises. It was a deposit in a bank account made from previous withdrawals. Paragraph. The court is unable to accept the above plea. A careful reading of the impugned order reveals that the SSC volunteered to explain the said deposit by referring to withdrawals from the account. Which totaled rupees 295,600. It is only the balance sum of around rupees 1 lakh for which there was no explanation. Paragraph. Consequently, the impugned order of the ITAT and corresponding orders of the AO and CIT-A would stand modified by reducing the addition to the taxable income of the SSC for the AY in question to the differential amount, that is 4 lakhs minus 2,95,600. It is so ordered. The appeal is disposed of. The question of law is answered accordingly. The appeal is disposed of.
Supplementary list item number 10.
Dear Your Lordship, I revenue frame the question. Is running page 4, 1 and 2. The finding is
Yes.
it is relating to year 7 and 8.
Suppression of sales.
Present sales, he has disclosed some amount and thereafter finding of the travel in favor of the RCC. But in the next page, page 46, as running page 46, internal page 4, therefore the amount of income is taxed to 1.5 crore as against 3.20, being a double tax effect to the income brought to the tax by the assessing officer under section 144 and 53A. The assessing claim cannot be allowed under the provision 69A, 69C, so far investment on disclosed source cannot be deducted under this provision. The tribunal reduced to tax to the tune of 1.5 crores as against 2.20.
That's okay.
Yes.
Yeah. The present appeal by the department is directed against the order dated 11th May 2012 passed by the IT80 in ITA number IT bracket SSA number 120/CTK/2011 dated 11th March 2012 for the year assessment year
7-8.
AY 2007-08. The question of law sought to be urged by the department concerns the deletion of an addition made by the AO on account of the suppression of sales paragraph. There's a detailed discussion
Para 9,
in para 8 of the impugned order of the IT80.
para 19.
Sorry. Yeah, para 19 of the impugned order of the IT80, where for the AY in question, the amount of income to be taxed was rupees 1.5 crores as against 3.20 crores. Open quotation being a double taxation effect given to the income brought to tax by the AO under section 144/153A, unquote. The conclusion reached by the IT80 in this regard appears to be perfectly legal, not warranting any interference. No substantial question of law arises. The appeal is dismissed.
Supplementary list item 11.
You can condone the delay at 157 of 2017 IA number.
Item 11.
None appears dismissed on opposition.
Supplementary list item 12.
In item 12, sir, we have no instructions from the client.
All right. Constitutional petitioner states yes.
11 and
11 and 12. 11. Acha, 12. This is 12. Yes, 11, sir.
11, there was there non-supply of dry foodstuffs to the ICDS center. This PIL was filed in the 2015.
Much has happened, sir.
Sir, if you restore that, it is no cause of action, the state.
All right. Constitutional petitioner seeks leave to withdraw the present petition to file a fresh petition if any cause of action survives.
Problem.
Disposed of withdrawn with liberty split.
Supplementary item 13.
Item 12, appearance of union noted, my lord.
All right. Sir. All right.
Item 13.
None appears dismissed from opposition.
Supplementary list item 14.
May it please your lordship.
Yes.
Item number 14, 15, 16. Kindly
Yes.
withdraw this matter with a liberty to renew the prayer if needed.
All right. With liberty to file a fresh petition if any cause of action survives.
14, 15,
Dismiss is withdrawn with liberty is paid for. Yeah.
Supplementary item 17.
Here, item 17, my lord.
I am appearing for OP number 5.
All right.
But a copy may be served so that I can reply.
No, in 15 she's withdrawn.
17.
17, acha, 17, sorry.
My Lord Senior is sitting in my matter. I think so.
17. You're in?
17.
I think he's in your matter is for 5.
Yes, my Lord.
What is the matter about, you tell us first?
My Lord, in fact, it's a matter, my Lord, a government land with kisam of jungle is about to be used by the private opposite party as a passage to his commercial
Anyway,
activity.
Mr. Mishra has made a representation.
To the
They'll issue
collector.
notice to you also. Let them first dispose the
What has happened actually, I don't know what he has made a government. So I was installing a petrol pump by the company that was given, allotted in my favor.
Right.
But the petrol pump land, that is my private land.
Right.
Between the public road and the private land, there is a strip of land about 8 to 10 feet.
Okay.
And if your lordship looks at every national highway, by the side before the private road, there is a patch of land, Noyanjori or the government land.
Right.
So that is only used to go to the land itself.
Right.
So therefore, a case was initiated by the Tahsildar. I gave a reply. I explained I am not using I am only using to go over to my land to use it for a petrol pump. Now the petrol pump has already been set in the meantime. The matter was decided by the honorable single bench here. A detailed order has been passed.
Oh, I see.
And the Tahsildar in the meantime, in the encroachment proceeding, has dropped the proceeding.
Oh, I see.
So there was no direction. The direction was that there should be no construction over the strip of land in between the land and the private
That
land.
is what our effort is, only to see that there should not be any permanent structure or construction.
No
We'll record a
construction.
statement that this is only being used for access. There's no
Yes,
question of
only
any
for use
permanent
of
construction.
access. But every national highway, if your lordship looks at petrol pump, anybody
200
will use
decimal
that
of land.
land itself.
But he's making a categorical statement that he's using that strip only for access and nothing else.
Yes, that's right, Bharat.
The only question we are raising about its character or nature.
That is not changing it, sir.
Yeah, it will never be changed.
Moreover,
It's only to access.
Beg pardon. My Lord Senior.
So that judgment is there. Yeah, my friend was conveying it, Bharat. He was the party in the trial court.
Me? I was not a party. With the villagers.
At your instance, it was initiated.
No. Who says? I think my Lord Senior has.
But anyway, he's making a statement that that strip of land they're not using for anything but for access.
Access.
Will your lordship allow me to, since my Lord Senior has already made a submission that the petrol pump is operative, will your lordship allow me 2 days time to take further instruction whether how it has been opened? Because fact remains, my lord, we are not in the way of his development, his own land. That's my Lord Senior is very fair to say that he's using the jungle kisam of land. So since a submission has been made by my
No, not
Senior,
using the jungle kisam. It's everybody is using it. But it is a strip of land.
it's a generalized statement, my lord.
National highway.
Perhaps it is the connecting passage from the highway to his.
But I have filed the document to indicate that, and in fact, it is the finding. It is, in fact, I have obtained the report at Annexure 3. My Lord Senior also may help me. Page 34, which clearly says that it has been illegally encroached.
No, this proceeding has been dropped.
Yes, but if your lordship kindly call for that.
This I have got on
judgment.
13th December. If my Lord Senior says so, let me take instruction for 2-3 days after. I will come back to your lordship, my lord, because we are not in the way of his development and his business, my lord. There is no question. We only want to protect.
That is WPC 19627 of 2021.
Okay. WPC civil
19627 of 2021.
Okay. 19627 of 2021. All right. The file of that requisition for the next date. Mr. S.P. Mishra and a senior counsel appearing on behalf of opposite party number 5 on advance notice states that a small strip of land separating the petrol pump operated by opposite party number 5 and the main national highway is being used for a limited purpose of access to the petrol pump from the highway and for no other purpose. Paragraph, constitutional petitioner seeks time to verify the details at his request list on 7th March or 8th March.
But a copy be given to me.
In the meanwhile, a copy of the petition be served on Mr. Mishra. All right.
Much obliged.
Supplementary list item number 18.
May I please, your lordship?
Yes, please.
My lord, this is a matter relating to violation of fundamental rights as enshrined under Article 19 and 29 of the Constitution of India. So for right to conserve the culture of a particular society at a particular place and a right to carry on occupation and trade. The residents of a hamlet village of distinct culture, skill, art, trade, and occupation, and also habitation.
Anyway, sir, there are representations. Let them consider that first.
I have submitted the representation before the opposite party number 1 and 2, my lord.
All right, let him consider it. You see, the petitioner's representation dated 29th December 2021, bracket Annexure 3 series, shall be examined by the collector.
Collector
Jashpur, opposite party number 3, after issuing notice to the petitioner as well as opposite party number 2, and after giving a hearing, a reasoned order should be passed thereon not later than 9th May 2022. The order shall be communicated to the parties not later than 16th May. The court clarifies it is not expressed anywhere.
My lord, may I pray one thing, my lord, before your lordship?
Yes.
Till disposal of my representation, I pray before your lordship, no mining operation.
No, it will be open to the petitioner to seek interim release before the collector. All right.
My lord, kindly direction may be passed to the opposite party number 2. Direction may kindly pass to the opposite party number 2 to consider my representation.
Not opposite party number 2.
3, sir. 3 is the collector.
We will consider. Collector will consider.
He will issue notice to 2. Yes.
Item 19.
My lord, may I pray one thing? Concerned collector of Jashpur district has been made a party, but the opposite party number 2 is a proper authority who will consider my representation.
No. You have addressed your representation only to the collector. If you want that relief, you better make a fresh representation.
My lord, my sole submission before lordship, kindly pass the order to the opposite party number 2 to
So you
consider
have to
my
make a representation for opposite party number 2. The representation you have made is only for 3.
No, my lord.
Yes.
I have made representation before the chairman Orissa Mining Corporation opposite partner 2 on 15th January 2022 under page 22 of my writ petition. That has already been now it has not been disposed of, considered.
So only the collector can consider this, sir. He will issue notice to OMC and they will also be heard. Yes.
My lord, till disposal of my representation, no mining operation shall be done.
So you have to stop. You're not listening to our orders. We have permitted you to take interim release before the collector.
Yes, sir.
All right.
Item number 19.
It may please your question. Hello, this is a PIL filed by one of member of our bar regarding the appointment of associate professor to the post of associate professor of in the bones and plastic surgery department of AIIMS Bhubaneswar, my lord. The person who has been selected, this is opposite 3 and has been given appointment on the basis of forced experience certificate.
When was he given appointment?
He was given appointment in 2017. Then, my lord, this was after the making the query, it was found that he has no experience. Then the representation was made by the petitioner to the director of AIIMS. The matter, the director of AIIMS called for the show cause from the opposition 3. 2 show cause he has been called for. He filed the show cause and it was not satisfactory. Therefore, under Annexure 9, your lordship can come to page 48. The governing body decided to initiate a disciplinary proceeding. Your lordship kindly, this resolution was passed by the governing body of the AIIMS on 22/11/2021.
Right.
At page 48, I am placing the small 5 to 6 lines. Initiation of appropriate action against Dr. Sunil Kumar Raut, associate professor in Department of Bone and Plastic Surgery, for not possessing the essential experience as per the relevant recruitment rules at the time of each initial recruitment. The member secretary has presented the agenda before the governing body. The governing body has deliberated the issue and noted that DOPT general instruction on the basis on the matter wherein it has been provided to conduct an inquiry as prescribed in rules 14 of the CCA rules. If it has been found that the government servant was found not qualified or eligible in terms of the recruitment rules, etc., for initial recruitment in service. In this case, it has been found that Dr. Sunil Kumar Rao did not possess the prescribed teaching or and research experience as required under the relevant recruitment rules at the time of his initial recruitment as associate professor, and his replies to the so-called notices were not found satisfactory. Therefore, the GB has approved to issue him a charge sheet under Rule 14 of the CCA rules by initiating a disciplinary proceeding matter. Since then, no action has been taken by the director AIMS matter. Experience certificate, your lordship kindly say annexed to he has produced, that is a post document.
All right.
That he has.
Mr. Manoj Kumar Mohanty, learned counsel appearing for the petitioner, who is the practicing advocate of this court, points out that despite the governing body of AIMS Bhubaneswar deciding on 22nd November 2021 to institute a disciplinary inquiry against opposite party
May I
member.
submit, my lord?
Yes.
Yes, my lord, she may come to the page 38 and 39, what my lord friend has annexed with the writ petition. There is annexes 7 and 8 respectively.
Yes.
The concerned administrative officer, the AIMS, wrote a letter to the concerned doctor and asked to submit this reply, then inquiry will be started like this. So this allegation, the AIMS is not sitting over the matter, not against steps, it's not correct, my lord.
No,
And,
no, Mr. Pari. The minutes at page 40.
Yes, my lord.
Relevant portion is at page 49.
49, yes.
No, 9, no, 1 minute. Page 48, bottom.
My lord.
So once you've decided to hold a disciplinary inquiry, you have to place the person under suspension or something.
Well, these two notices were issued. He filed the one first notice was issued. He did not file the so-called. Then second issue, what my learned friend is referring. That so-called notice was issued. Thereafter he filed. You was asked to produce that your appointment. Thereafter, after considering the so-called filed by a person to these two notices, my lord, that the governing body has taken the decision.
No, so Mr. Pari, the only simple issue now is why have you not initiated the disciplinary inquiry and placed him under suspension? I think that's the question, correct?
That instruction I will take, ma'am. That instruction.
You take that. That's all. We're just dictating that.
Yes.
Read the whole sentence, sir. Kindly read what you dictated. petition brought forth by a practicing advocate of this court, questioning the failure of the AIMS Bhubaneswar to take follow-up action against opposite party number 3 pursuant to the decision taken at the meeting of the governing body of AIMS Bhubaneswar on 8th November 2021. Paragraph Mr. P.K. Padil and ASGI appearing in advance notice for AIMS Bhubaneswar bracket opposite party number 2 states that he will seek instructions on what action has been taken. At his request list on, we'll have it next week.
Yes, ma'am.
9th March. All right. All right.
Sir, in fact, Mr. B.K. Padi is appearing.
Okay. All right.
Along with CGC.
Yes.
Supplementary list for admission, item number 20.
My lord, this is a PIL going on since 2002. It's a very difficult PIL and it is all along been conducted by Mr. Narsingh Mishra. And last occasion it was listed on 6/12/2021 and your lordship has fixed it today.
Yes.
I received information yesterday evening that he was coming, but due to some unavoidable difficulties, he could not come and he intimated me. So I had to rush today morning to get the file because his chamber is at Bhubaneswar.
Okay.
So in this background, my lord, if your lordship can accommodate Mr. Mishra sometime in March or April, March first week or second week or April.
All right. At the request of Mr. Narsingh Mishra, Bernard Counsel, Mr. H.S. Mishra says that Mr. Narsingh Mishra, who is
because all along he has conducted, I've never conducted the case.
all right, who's been conducting this case throughout, is in some personal difficulty today. At his request list on 11th April. But please tell Mr. Narsingh Mishra that he can appear from wherever he is, virtually.
In fact, my lord, I told like that online from because he's at Balangir to appear, but because of some difficulties, probably he could not do. Or he probably he's not that computer savvy. He's still poorer than me.
No, just sitting before a camera. That's it.
No, my lord, this whole point is that we are late. We cannot fit in, and that is why we are now slowly withdrawing from the profession.
No. Don't have to, please.
No. And probably because of my personal reason, also we may not meet for another 4-5 months.
You convey to Mr. Narsingh Mishra that we still need him very much in our courts.
Lord, in fact, my lord, only in public interest litigation since last 30 years, some 4-5 cases he has conducted. He is not in the professional earning profession.
Okay.
It's a very your lordship can see. Probably this is a difficult case. What I have been hearing from 2002, the state is consistently in view of the confirmed judgment of 2002. They are not going to obey. That's why contempt also is pending from 2012.
Anyway, we fixed it for 11th. We fixed it for 11th, sir. We fixed it for 11th April.
Judgment in 2002.
All right.
They perpetually and continuously never complied with. That judgment was affirmed by the Supreme Court also.
Okay.
And thereafter, contempt was filed in 2012, but some other could not be listed at once or twice.
All right.
12 March 12.
11th April. Right.
My lord, one subject. My lord,
Yes, Mr. Nayak.
My lord, I had filed a written note.
Madam, 11 March.
Yes, 11th April, sir. 11th April.
April, oblige, madam, oblige. I will intimate, madam. I
My
will
lord,
convey your lordship's
and
order.
an additional affidavit dated 23rd of November 21. That does not seem to be there in the list. Maybe
So
it's
you
not
trace
there.
it out, Mr. Nayak. You have someone come here and inspect. You trace it out and place it on record. All right.
Supplementary list, item number 21.
My lord, may it please your lordship, my lord, I am appearing for the petitioner.
Yes.
Last date, as I had requested your lordship, my lord, that I am filing an application for amendment. I have filed in the meantime. If your lordship looks at yes, flag D, flag T, my lord.
Petition for amendment, correct.
In that amendment application, I have already brought the subsequent events after filing of the writ application.
All right. Say 12591 of 2021. Who's for the other side?
Yes, my lord, I am appearing for opposite part number 2 and 3.
Right.
As a special counsel for Department of Energy, Government of Orissa.
Okay, sir.
My lord, I have filed objection to this amendment, stating that this amendment is grossly delayed. It has been filed after 15 years, 6 months and more than that. And there is the cause of action is fresh, for which he can file another case. But question is, what is now brought by way of amendment was available to him in the year 2007. He sat tight. Now, Mr. Melody, in this case, Mr. Parija was appearing.
Right.
The present Advocate General, because of his present situation, Mr. Mishra has been engaged. Perhaps he thought that an amendment is necessary. But
Right.
I have filed my objection. Your Lordship will kindly see. What was the?
When did you file your objection, sir?
Yes, my Lord, my objection is filed on 8/11/21. That is also mentioned in the list, my Lord.
Yes, 511.
Yes. That is mentioned in the list. Yes, that is my objection to miscase. That is IA 12591. Is it at flag T?
We have the amendment application, but we don't seem to have the reply.
Oh, then, I have filed it on 8/11/21 in the registry.
Mr. Mishra, do you have that?
Yes, I have got a copy, my lord.
Yes, I served a copy on him.
I have got a copy, 5/11.
So your Lordship call it some days after. I will search or supply copies to your Lordship.
All right. The petitioners reply, sorry, the reply of opposite parties 2 and 3.
Yes.
To this application, you say IA number 12591 of 21.
Yes.
The reply of opposite parties 2 and 3 to the present application be brought on record. List on.
Which is filed on 8/11/21.
All right. List on 23rd March, sir.
23rd March.
Right.
Published.
Supplementary item 22.
May I please, my lords? One senior member of our bar was also at Delhi for some time. Mr. Vijayananda Mahanti barrister is the petition before my lord. His grievance is he was assessed to the income tax for assessment of 2005 and 6 way back in 30th October 2005. Then, as per the law, 6 years is the limitation going to expire 31st March 2012.
So we'll continue the interim order. Let him go in appeal, sir. This is assessment order, no?
Yes, assessment order. And let me see one interesting thing. Why I have come here? My lord have also appreciated and granted interim stay. Appeal is, I know, my lords. The only thing, my lord, kindly see the order. For a moment. Next 2 is the notice of 148.
Yes.
Assessing hereby request that the Annexure 1 is the notice of 148. Whereas I have reason to believe that your income, with respect to which you are reasonable, accessible to income tax 256 has escaped assessment at 147. So no need notice. Then on the next, that was received on 23rd March 2012, 7 days before the last expiry of reopening. On 5/4, I applied that you give me the reasons, Annexure 2, because reasons for initiated proceeding, give me. Did not give. Then I appeared before him on Annexure 3 and 3A for that purpose, but he was not absent. Then, my lord, Annexure 4 is order passed. My lord, see the Annexure 4 for on page 16. For a moment. My lord, see column number 11 of that table. Date of hearing 2nd March 2012, 7th March 2012, 23rd March 2013. Well, the notice is issued on 23rd March. How can you hear argument on 2nd March and 7th March? One thing. Then only it remains 26th March is the only date. And my lord may remember 31st March is the last date for completing the reopening assessment. Now what he has done, now he did not also disclose before me the reasons. And the order he says that I have invested 1 crore 26 lakhs but through bank. No material was given before on the order also on the reflect. Perhaps I have given that some building dealer, property dealer at Delhi had advanced some money. And he said, you have given 1,26,000. Where is the details? No details. But man, see, I am reading para 17. May I place me? Para 17.
Para 17 now?
Para 17, page 17, second paragraph, third paragraph further. From the documents and written submission filed by AR of the assessee, it is found that the assessee has invested 1,26,50,000 in land project by making payment to Sri Sahil Gupta and associate from time to time. Where is that material? My say I have only 75 lakhs, I have produced the records. Where is the basic need that I have invested 169? Onus is on the revenue to say I have made investment. They say here, from the documents and written submission of the authority to the assessee, he found that 1 crore. Where is that document? There is no mention here. And then they said that you demand 51 lakhs added to my unexcluded income, 169.
So because explanations for 75 lakhs. So
Most interestingly, I will kindly see page 19. Page 19.
So we can confirm this.
I see what he has done. He has backdated this order. And another thing, he now writes issue 271C notice, page 18. That is order is dated 31st March. That is the Sunday. 31st was the Sunday. And 170 notice he has issued on 26th March. Before passing the order in the assessment order, issue the notice on Annexure 5, 26th March 2012, 13th he has issued. All these are things manipulated. At least I was given opportunity to explain what is there. What I humbly pray subject to my Lord's acceptance. I pray now that he has saved the limitation as per the law books. 31 pass the order, right or wrongly. I pray let him give me a chance, further chance, and frame the assessment again, so that I can explain what is the thing.
I leave it to Lordship, but the fact remains that assessment starts from running to 16. He has said that there's no basis. Basis is there. There may be some.
You're not giving him the reasons.
Yes, Your Lordship may direct to place assessment, Lordship. But Your Lordship. Yes, I am not. But the fact remains is not, that is the basis, because a criminal case investigation is made at Delhi.
No, but those reasons have to be furnished to him.
Yes, similarly, the reason, but he has participated, Lord. That's
what.
That for me, Lord, I say, Your Lordship, I leave it to Your Lordship that
the challenge in the present petition is to a reassessment order dated 31st March 2013 under Section 147, read with Section 143 of the IT Act of Income Tax Act 1961 bracket Act for assessment year bracket AY 2005-06. In the present case, notice was issued to the petitioner under Section 148 of the Act on 23rd March 2012. Surprisingly, the order of assessment indicates the dates of hearing to be 2nd March, 7th March of 2012 and 26th March 2013. There could not have been two dates of hearing prior to the notice itself. So this itself indicates a lack of application of mind. Paragraph. Secondly, it is not disputed by the department that despite the assessee writing to the assessing officer bracket AO on 5th April 2012, requesting for reasons for reopening of the assessment, those reasons were never furnished to him. Thirdly, it's pointed out by Learned Counsel for the petitioner SSC that an adequate opportunity to explain to the AO the version of the SSC in response to such reasons has been denied to the SSC. Paragraph. The court is satisfied that there are procedural irregularities that warrant a fresh order of reassessment to be passed after giving the SSC the reasons for reopening of the assessment. That view of matter, the impugn assessment order is hereby set aside, and the following directions are issued. 1. On or before 4th April 2022, the AO will furnish the SSC with the reasons for reopening of the assessment. 2, consistent with the rule in GK and drive shafts, the assessee will be given time till 2nd May 2022 to submit his objections to such reopening of assessment. 3, an order on such objections will be passed by the AO not later than 5th June 2022. Paragraph, if the AO decides to then proceed with the assessment, he will do so after duly issuing notice to the assessee, giving him a hearing, and then passing a fresh assessment order in accordance with law.
Except time may also be consequentially annulled.
In view of the above order, the notice dated 26 March 2013 under section 271(1)(c) of the Act is hereby set aside. The consequent demand notice at annexure 4 by A is also set aside.
You will appear before the authority on 4th.
No, you apply the regions.
Right.
Urgent certified copy.
Supplementary list item number 23.
PIL matter and might have been included 2014 matter. In person, he is appearing.
Yeah, he's there.
I am a practicing advocate of the High Court matters. I have filed the writ application challenging the action of the state government by the annexure number 1 and 2. They have opened that diploma in medical laboratory technology course and diploma in medical radiology technology course without approval of the AICTE matters.
You Lordship, may kind on to page 21, annexure 2.
Yes.
That was issued relying upon annexure 1. That was for 2013-14.
Yes. Because
that period has gone.
Because the same thing was challenged before the Honorable High Court matters. I have quoted the order matters at page 8, paragraph 4.7. Paragraph 4.7 matters.
No, but that batch is over now, right?
The batch, but now my lords, without approval of the AICT, they have directed the state government directed the Persons Trust Society Private Hospital to open the DMLT and DMRT courses, my lords, without approval of the AICT, my lords. The AICT approval is required, and the Honorable High Court, my lords, by WPC number 4624 by 2003, hold that without approval of the AICT course, that the course will not be opened, my lords. And in spite of, my lords, that is that the AICT also given a notice, my lords, that is, I have annexed.
No, sir, this DMLT, DMRT course.
That is, yes.
For which advertisement is issued on 3rd December, annexure 2.
Yes.
That is over now, right?
Now, yes, that has been over, my lords.
So your only relief was for that annexure 2.
Now, my lords, I am challenging the action of the state government because the institution which are not approved by the AICT, they are directed to open the DMAT and the DRT courses. And by virtue of this order, my lord, kindly glance to annexure 1, my lords.
Annexure?
Annexure 1. State of Orissa is facing acute shortage of laboratory technician and radiographers. Government have created 954 laboratory technician posts.
Sir, and in these
existing AICT approval is not required. This is the state government.
So the problem, can I, if you with your permission,
yes,
you filed this in 2014.
Yes, my lord.
Since then, how many courses of DMLT, DMRT has been conducted?
Because they have given a chart of that. They have given a chart that these.
I'm asking some question. You are saying something else. If you don't understand the question, I'll request Justice Patnaik to ask you.
Sorry.
How many courses have gone by in the meantime since 2014?
Only DMRT, only 2 courses, my lord.
2 courses.
DMRT.
This is 1 year course?
No, this is 2 years course. My.
No, 1 minute. So those persons have passed?
These persons are passed.
Who are the persons who have passed?
Because they have given permission.
No. Today we allow your repetition. What happens to their diplomas?
No, I am not, because I am challenging the state government action, my lord, so without approval, without.
So if we allow your repetition, what will happen to those people who passed out?
They will be passed out. And
what will happen to them? Suppose we allow your repetition, what will happen to them?
That certificate, as per the state government.
Everything will go.
That as per the certificate.
And if they're employed somewhere, they'll lose all that employment.
No, that certificate will be genuine, my lords. Because my
sir, if the course is not recognized, your prayer is that this is not without the permission of the AICTE.
Now they have directed the state government to directed that to the public, my lords, public trust.
You're not answering, sir. You're not answering the consequences of your prayer being allowed in 2022.
Yes.
You've allowed the whole thing to sleep over. It so happened we have listed it on our own, this writ petition. Otherwise, you're not interested in this writ petition. Because you filed it in 2014, you're now appearing. You never made an effort to get this listed. You allowed 2 batches to be over. They've got their diplomas. They're now employed probably somewhere. We don't even know who they are. And behind their back, will be allowing your writ petition, jeopardizing all the diplomas they have got.
No, because
You don't understand the consequences. You're not bothered about the consequences. You're not bothered, correct?
my entire end of your, my lords, that is, they have directed the other.
Sir, we allow your writ petition today. What will happen? You tell us that.
Then, my lords,
You see, given the nature of relief sought for, and with there being no interim orders by this court over 8 years now, and 2 batches, and admittedly 2 batches of students already having passed out the DMLT and DMRT 2-year courses in the meanwhile, the court does not consider it appropriate to continue entertaining this writ petition, which was filed in 2014, challenging an advertisement of 2013. It will be open to the petitioner to file a fresh petition if any course of action survives. The petition is disposed of.
Supplementary list item 24.
May I please understand? 24.
This unauthorized construction is taken in a separate. You see, the issue of unauthorized religious structures is being considered separately in other PILs of this court. Consequently, there's no need to entertain one more petition, the same issue. Petition is disposed of.
Supplementary item 25.
Disposed of.
Item 25. May I please understand? My lord, in this public interest litigation, petitioner challenged annexure 7 passed by the collector Sundargarh, running page 22-26, and second prayer include his name in municipality election, but the voting right is a constitutional right of the villagers. The collector as well as the state authority absolutely no any discretion to delete their name from the voting list. But the considering, and that is a second round litigation, Honorable High Court directed earlier by the Annexure 4 to consider and reasonable order pass. But the collector illegally, without considering Annexure 1, Annexure 2, and Annexure 5, illegal order passed.
The prayer of the petitioner is for inclusion of the name in the voter
There are
list
statutory provisions
for the
for all
2015, yes, 2015 election. That election is over.
Yeah.
The coming election?
Yes.
You file a fresh application, sir. There is a statutory provision for
No, my
that.
lord, that the Annexure 7, the collector decided, I am not a voter. Man. This is the voting right of the villager.
That is for that election, sir. For the fresh election, you file.
Election over, but a coming election?
That you file a fresh application. You say.
No, my respectful submission, the learned collector decided that Tarapur villagers have no right or no voter of the municipality.
All right.
That's the
See,
finding.
the prayers pertain to the municipal body elections of 2015, is it?
My lord, 2015.
Which is long since over. Paragraph, if there is any subsisting grievance about non-inclusion in the voters list for the coming municipal body elections, it will be open to the petitioners to seek appropriate statutory remedies in that regard in accordance with law. The petition is disposed of.
Supplementary item number 26.
26, no instruction. No instructions.
I am appearing for OP number 5.
Supplementary item 27.
27 and also no instructions.
No instructions.
Supplementary item 28.
28, no instruction, Your Lordship.
No instructions.
Appearance of innovative noted.
All right.
Supplementary item 29.
None appears.
Item 29 is a PIL where the petitioner has paid for sanction of the sanction for purchase of equipment for the broadband at Bhimsar Bulla Mala. What has happened, my lord, the one Red Cross blood bank is there in the under the Bhimsar Bulla. By the collecting user fees, the blood bank was running. Then still it is also running, my lord. But on the users fees, the collection, they have constructed a building and shifted to the new building. They don't have any funds for purchase of machinery, latest machinery to run the blood bank. So they have times and again the authority.
So you're not updated anything in the last 6 years. What has happened in the last 6 years, you don't know.
Today also morning, I have taken instruction that government has not sanctioned a single rupees.
All right. File a fresh representation. Considering that 6 years have elapsed since the petition was filed.
My lord, my representation is there and
You have to file a fresh. The petitioner is permitted to make a fresh representation to account for the events in the meanwhile, highlighting the issue raised in the present petition. The petition is disposed of.
Supplementary item 30. Item number 30.
None appears. Dismissed.
Supplementary list item number 31.
31 is regarding some illegal prawn gheris in.
There are enough PILs, sir, on that.
Yes, that is, but in the meantime, no instruction also there. So if cause of action survives.
No, you see, counsel for the petitioner states he has no instructions. The court is anyway dealing with this issue of illegal prawn gheris in other PILs already pending this court. The petition is accordingly disposed of.
Supplementary list item number 32.
32, the prayer of the petitioner now infructuous. My lord, they have complied.
Petition has become infructuous.
I'm appealing for the
Mr. Sapati.
All right, sir.
Supplementary list item 33.
None appears. Dismissed for non-prosecution.
I'm appealing for the opposite party number 2.
All right.
Supplementary list item number 34.
None appears. Dismissed for non-prosecution.
Supplementary list item number 35.
35, Your Lordship, as I filed an affidavit on 5/2/2018, para 7. I have complied the Honorable Court's order.
All right. An affidavit dated 8 March 2018 has been filed.
Para 7.
In which it is stated that the chairman CBDT, New Delhi, has decided that CIT exemptions Hyderabad will hold a monthly camp at Bhubaneswar for the convenience of the SSCs in Orissa. In that view of the matter, no further directions are called for. The petition is disposed of.
Supplementary item 36.
Item 36, my lord. I have challenged the annexure 1 and 2. That is the miscellaneous application filed. My lord, kindly have a glance to my grounds of appeal. As at page 45, my lord, the ground number 3 and ground number 7. Ground number 3, and that is for that, it is a fact that during the preceding assessment years, the plant and machineries were used by the appellant firm, and during the relevant assessment year, the plant and machineries were kept ready for use. But for the order of the restriction put by the government of Orissa, the plant and machineries were not allowed to function and to be used.
No, when was it actually put to use that you have not given?
Well, the government now allowed only to dispose of the old matters, old new we have not granted, and there is some dues pending.
When did you actually put it to use? You never put it
as
to
per
use.
instruction, my lord, the next year they have allowed to function the plant and machineries. And now they have cleared the government dues, outstanding dues.
Anyway, what is challenged before us is an IT-80 order of
My lord, kind of,
4th September 2019. That's all you've challenged.
my lord.
What is wrong with that order, you tell us?
That is only on the ground that my lord, kind of have a grant to the para 29. On pressure of the CIT confirmed the action of the assessing officer as the assessee failed to produce any evidence for use of the plant and machinery for the business of the assessee. The argument of the law and air is that the plant and the machinery were kept ready for use for the business of the assessee, and hence the assessee was eligible for depreciation for the same. On a query by the bench to the law and air as to when the plant and machinery in question are put to use by the assessee in the subsequent year, they could not reply to the same. My lord, they could have granted one more time for to take to instruction. For on that ground, enter my appeal dismissed. It's a prejudice, my lord. Violation of so my humble prayer is that the matter may be restored for reconsideration of the appeal as per ground number 2 and 7. And there is decision. I am relying on decisions. And the last occasion I filed, but now I have also filed. Our jurisdiction of High Court also. And that the serial number 2, my lord.
There is no mistake. This 254-2 is not a strong point.
On the query, only on the ground of query, my lord. Let them explain that, and also there are judicial decisions, and on that basis, one on a single day, without giving another time opportunity.
Where's the need in a review petition? Why more and more opportunity?
I have filed a miscellaneous application for recall of the.
That's what recall, review, whatever you call.
That is on Annex 1, my lord.
More time in that.
Annex 1 is that order, my lord. Miscellaneous application disposal of that. My lord, the para 5 maybe have gone to page 15, my lord.
Yes.
Para 5. After hearing the submission of both the parties and careful perusing the tribunal order, we observe that the tribunal has confirmed the order of the CIT on the basis of material evidence available on record. Lord and Air before us submitted that the tribunal has not considered the grounds of the assessee with regard to the fact that assessee was eligible for depreciation as the plant and machinery were kept ready for use for the business of the assessee. However, on perusal of para 29 of the order of the tribunal dated 4/8/2017, we find that the tribunal during the course of hearing proceedings has queried the assessee as to when the plant and machinery were put to use by the assessee in the subsequent year. However, the assessee could not reply the same. Therefore, we are of the opinion that there is no mistake apparent from record. A non-consideration ground of appeal is a mistake apparent from record as per decision of our Jurisdiction High Court, my lords. The Orissa High Court have already passed in reported in 203 ITR 64. A camera grounds that is at page 27 to 29, my lord. The relevant para is at 28 the bottom. This was the case. My lord, may I read?
Yes, yes.
The last bottom para, my lord, page 28. This was the case when the conclusion were in favor of the assessee. The tribunal has merely noted the argument advanced on behalf of the department and the assessee. No definite conclusion on the vital aspect have been arrived by the tribunal, as is evident from the paragraph quoted above. The tribunal was duty bound to examine the point raised by the parties and to record definite conclusions in respect of each one of them. The tribunal having failed to do so, we feel that the matter should be reheard by it. It has to be indicated reasons in support of its conclusion, and merely saying that the paper book have been gone through or fact have been examined is not sufficient. My lord, here the main contention is that they have raised the specific ground, my lord, and the decisions were also relied, and it is a settled principle of if the plant and machinery are kept ready, the depreciation is allowable. And that matter have not been examined by the tribunal. Only on a query, they have disposed of the.
Yes, that's fair enough, sir. The challenge in this writ petition is to two orders of the IT-80, one dated 4th August 2017 in ITA number 28/CTK/2016, the other And why did you file writ petition? You should have filed an appeal.
Against the MA order, my lord, the annexure 1 is the MA order.
Annexure 1 is MA, Annexure 2 is not MA.
No, my lord. But I am against the
In
MA order.
ITA
That
number.
it is a.
But your prayer clause you challenged 2 also, Annexure 2 also.
Well, if you the matter to be, we had the both order to be quashed, my lord.
Is to an order dated 4th August 2017 passed by the IT 18 second in ITA number 28/CTK/2016 for the assessment year bracket AY 2010-11.
No, my lord, that is 11-12.
Sir, Annexure 2, please see assessment year.
That is a department appeal. That is for the second.
No, your appeal also.
Yeah, my appeal is they have wrongly.
Okay.
But the,
11-12 and the order dated 4th September 2019 passed by the ITAT dismissing the SSC's misapplication number 35/CTK/2017 under section 253, is it, of the Act of the Income Tax Act 1961 bracket Act. This court has heard the submission of counsel to the petitioner and the counsel to the department. The issue before the CATA and the ITAT was about the AO having disallowed depreciation in the sum of rupees 57,03,909 on plant and machinery on the ground that they were not used for the business of the SSC during the AY in question. Paragraph. A query was raised by the ITAT for which the SSC did not have a satisfactory answer. This is reflected in para 29 of the impugned order of the ITAT dated 4th August 2017 and reads as under reproduce para 29, page 27. Paragraph this led the SSC to file misapplication number 35/CTK/2017 for recall of the above order dated 4th August 2017. This was dismissed by the ITAT on the following reason. For the following reasons: you say reproduce para 5 at page 15. Having heard and counsel for the parties, the court is unable to be persuaded that the ITAT committed any serious legal error in coming to its conclusions both in the original order dated 4th August 2017 or in the subsequent order declining to recall that order.
My lord,
no substantial.
The question of law, there is no. I have challenged the MA order, my lord.
Correct.
And the decisions.
The court is unable
saying
to
that
find any legal error
non-considered-
vitiating the impugned orders.
My lord,
the writ petition is dismissed.
The decisions have supplied that it is already settled, and the Honorable Delhi High Court full bench already decided that matter in 330 ITR that non-consideration of decisions and the non-consideration of ground.
Sir, first facts, only then decisions. On facts, most of you are weak on facts, so keep on piling decisions.
My lord.
Decisions will come after facts.
Yes, my lord. But here is the only the ground that when asked and he cannot reply.
Right.
And if the heir of the SSC failed to reply that matter, on that ground, one chance could have been granted.
That's why you filed a recall.
Yes,
Even in the recall application, you did not satisfy.
No, they have not asked for that.
No, it's fine. Yes.
Supplementary list item 37.
May I please, Lordship? I am
Yes.
appearing for the petitioner, my lord, in this case.
Yes.
And this is with regard to the construction of railway link from Talcher to Bimlagod, my lord. That is a vital.
Item 37. No, there are
37.
two items. In the first item, though I have filed the counter in the month of September 2021 by e-filing, that is not there. Today I am filing the hard copies. So also in
Mr. Murali states that he will be submitting the hard copy of the reply.
I have already submitted.
A copy may be served on me, my lord.
Copy be served on counsel for the petitioner. Rejoinder be filed before the next date.
In the second case also, I am filing.
List on 5th May.
In the second case also today I am filing the
both
hard
matters.
copies.
Right.
Copy may be also served.
Yes, sir. Yes.
Supplementary list item 38.
I will also be fixing it to March, my lord.
5th May, sir. 5th May.
Supplementary item 38.
May please, your lordship.
This is a PIL filed by Native Voice, an NGO. They challenged the illegal transportation of minerals by village road and reserve forest.
I thought I passed a detailed order this.
Your Lordship has directed to form a committee.
Correct. What happened?
Committee has submitted a report. My learned senior appearing for the state has also filed a complaints affidavit and counter affidavit in law.
Well, in fact, your Lordship may kindly say, his allegation is against the private opposite party number 6.
6, my lord.
Entire mining operation has been stopped since 13/8 to 2021, and thereafter, for extension, all those requisitions are filed. That has also been disposed of by my lords. So that at present there is no chance of any transportation.
But my lord, at that
and
point
one
of-
more provision may I submit, your Lordship, may kindly say, Motor Vehicles Act, Section 115. 115. That is at page 151, my lord.
Yes, power to restrict use of vehicle.
Yes, the state government or any authority authorized in this behalf by the state government, if satisfied that it is necessary in the interest of public safety or convenience, or because of the nature of any road or bridge, may by notification in the official gazette prohibit or restrict, subject to such exceptions and conditions as may be specified in the notification, the driving of motor vehicles or of any specified class or description of motor vehicles, or the use of trailers either generally in a specified area or on a specified road, and when any such prohibition or restriction is imposed, shall cause appropriate traffic signs to be placed or erected under section 116 at suitable place. Now, my lord, may kind turn to Orissa motor vehicle rules. Rule
So what is the
100
point? You make your point first.
Well, I want to submit that the power lies with the collector to impose restrictions on the vehicles if and when situations arise. If such situation arise in future, they can approach the collector.
All right.
That provision, my lord, may kind turn to page.
That's fair enough. And we've issued a
394.
set of directions in some other PILs.
My lord, in their SOCUS notice to the OP number 6, they have specifically mentioned it that there is no environment clearance for operating through the.
So mining is stopped there, he says.
Now it is stopped. My lord, but the restitution and the my lord, environmental compensation, they have not written anything about that.
You can always go to the NGT for all those things, sir. You say the mining operation in the area has completely been stopped. Further directions have been issued in some connected PILs on the transportation of minerals to the areas in question. It will be open to the petitioner to file a fresh petition if any cause of action arises in future. The petition is disposed.
May I submit one thing, my lord? The learned counsel for the state has mentioned in their counter that the road involved is a old mining corridor. But at present, the revenue record shows that it is a Kacha road, and the road has been illegally constructed by the private opposite parties without the permission from the authorities, from the forest department and from other departments. And this road goes through the reserve forest.
All right. You see, if there are any other environmental issues, it will be open to the petitioner to raise them before the appropriate forum. All right.
Oblast.
Supplementary item 39.
May I please, your lordship? In item 39, notice was issued by reasonable court, noting it that AD is not back from opposite party number 8.
Fresh notice be issued to opposite party number 8 by Lord, 8 for
OP number 8, I am appearing.
I see. All right.
For it go.
I see.
They have appeared on 22nd, my lords.
All right. You
Lord,
want to file a reply?
My lord, we have also obtained instruction. We will file our counter affidavit.
We'll file a state also has to file, my lords, contesting.
All right. Replies be filed within 8 weeks, rejoined for the next date.
But with the lordship's kind permission, may I be pardoned? Item 33, I just missed it. I am extremely sorry.
Yeah, 1 minute. 10th May. This is 10th May. Item
33, I was only submitting that the grievance of the petitioner has been redressed in the meanwhile. Only that much I am praying.
33, the petition has been rendered infructuous. It's disposed of as such.
Much obliged.
All right. All right.
Supplementary for hearing, item 40.
Item 40 may please, my lords. But this is a public interest litigation, my lord, again filed by a senior member of the bar, my lord. But this has been filed on the basis of the judgment of the Honorable Apex Court, where the direction was issued to streamline the process.
Appointment of law
Yes.
officers. What's the latest? This was filed in 2016.
Yes, my lord. In fact, my lord,
After which several law officers have been appointed.
yes, my lord, I bowed on. But
Ah,
so
so-
far as the guidelines which have been
You
framed by the
file a
Honorable
fresh
Apex
petition
Court-
if any cause of action survives, sir.
My lord, my humble submission would be there are rules to that effect, my lord, which I have annexed.
Yeah, the law
Rules
ministry as
does
a
not
party
say
would
so.
do that also.
The rules does not provide for any of the guidelines which have been framed by the Honorable Apex Court. For a moment, my lords permit, I will take my lords to the judgment of the Apex Court. The
See, there
guidelines.
should be any, is there a current appointment process on?
Yes, my lord. There are rules, my lord.
No. Right now, is some appointment going to happen?
But to that effect, my learned
Ah.
senior for the state, my lord.
Whenever a new fresh set of appointments happen, we'll examine the issue, sir.
Lord,
You
my-
see, this petition was filed in 2016. That is 6 years ago. In the meanwhile, there have been several appointments of law officers. In the event that there is any further appointment of law officers which is imminent, it will be open to the petitioner to file a fresh petition. Right,
May I
the
pray, my
petition is
lord?
disposed of.
May I pray one more thing? my lord? The cause of action still survives, my lord, because there are already rules. My humble prayer is only.
When next time they appoint X, you challenge it. All right.
The appointments.
Union of India appearance may be noted.
All right.
I am the J. Naik.
All right.